Happy to be here. Thank you to everybody that joined us, and I hope people can continue to join. We do this every month, the third Tuesday of every month now. So the next one's coming up in March. That's going to be our quarterly bail, which is banker, accountant, insurance, and legal advisor. But tonight, we're in for a great presentation. Chris was with us, if those of you that joined us in January. And Chris Green is back with us tonight from Cline Williams. And his practice areas include business organization, franchising and distribution, intellectual property and technology, and mergers and acquisitions, and really focusing on the general transactional matters. He's a Creighton graduate where he was magna cum laude in 2021 and has been a great supporter and great advocate both for small businesses across Nebraska as well as NEF. So with that, I'm going to turn it over to Chris. We will have some handouts that Leo will be able to load as downloadable sample copies. Only disclaimer, just remember this is for training purposes. So anything you hear tonight is for training purposes. It does not constitute, cannot constitute legal advice. Always check with your individual attorney or lawyer. Make sure you're getting the best advice. But again, this is going to be great stuff tonight and great first step. So Chris, I'm going to turn it over to you.
Thanks so much, Jim. As Jim said, none of this constitutes legal advice. You should contact an attorney if you have questions or need tailored documents or advice for your situation. Every situation is unique. But anyway, as Jim said, my name is Chris Green. I work at Cline Williams, Red Johnson, and Oldfather. I do a lot of transactional work, corporate work. And so tonight we're going to be talking about governing documents for corporate entities, or for entities in general. So there are three types of entities that we're going to be looking at tonight.
Yeah,
Give it just a second. You guys will have a PowerPoint slide to look at. So
looks like everybody's joining all at once, so it's a little bandwidth issue, but let me get you guys.
All good.
There is. All right.
Perfect. Take me to the third slide, I think. Perfect. All right, we're going to be talking about limited liability companies first and their operating agreements, which is what we call the governing document, thing that decides how you run business. Corporations, we're going to be looking at bylaws, and then partnerships, we're going to be looking at partnership agreements. We're going to start off with LLCs. Next slide. So as you go through and think about how you want to structure your business and how you want to operate your business, you have a couple of different considerations. You know, how do you actually make decisions and conduct business? What is the process by which you're going to decide whether or not you go with supplier A or supplier B, what you're going to set your prices at, whether you're going to invest in a piece of real estate? These are important questions and you need to have an answer to them. How are you going to handle the distributions of profits and losses? So hopefully, if you start a business, you make some money. How is that going to get paid out? When is that going to get paid out? Who's it going to get paid to? Who gets to be part of the entity? For corporations, this is a little bit different, but for LLCs and partnerships, you get to decide to some degree who gets to be part of your entity, who your business partners get to be. You may want to have a lot of control, but you may want to have a little bit of control. Another issue that you really want to think about up front, we're going to talk about this more toward the end of the presentation, but is disputes, how to get out of the entity, how if everybody gets really excited when they start a new business, everything's going great, they're going to make a ton of money, everything's going to be wonderful, and they're going to be best friends forever until 6 months in something happens and there's a disagreement between the parties, and working out how to resolve those issues beforehand is going to be far more productive than sitting around and waiting to try to find those issues later on. So starting off, we're going to look at operating agreements. Start with management. These are sort of the elements.
Mm-hmm.
Okay. We're going to be looking at sort of these elements: the management structure of the entity, the equity structure. Equity just means the money that goes in, comes out. Limitation of liability, books and records, restrictions on transfers, and then termination or dissolution. Before I go too far, on the handout that you guys have, that is a single member operating agreement. Really hard to tell the difference here, but it should say formation of company under Article 1. Here, I will.
And for those of you online, we'll be sending that out, texting it out in the next minute or so.
Should be coming to you before too long. To start off with here, you'll notice that it just starts with formation. This is the name of the entity. This is the designated office where you get mail. This is who your registered agent is. These are kind of boilerplate things, but you want to be sure that you have them in your agreement. Same thing's going to be true of your bylaws to a greater or lesser extent into your partnership agreement. One of the things to note is that LLCs can be formed for particular terms, so they don't have to last indefinitely. Most of them do. But for instance, if you and your 3 buddies decide you're going to go sell water for the College World Series, you can form an LLC just to sell water during the College World Series. When the College World Series ends, the entity goes away. Not necessarily something you want to do, but one of the options that these have. All right, get into a little bit more of the meat here. We are going to be looking at the management structure of LLCs. And so this is something that you can, that when you are preparing your operating agreement, you're going to want to have access to, that you want to think about a lot. And so it's kind of one of the first questions you're going to need to answer. Thank you. You have 2 choices with an LLC, which is a manager-managed management system or a member-managed management system. Under a manager-managed system, the manager gets most of the authority to make the day-to-day decisions. So if you're choosing between supplier A or supplier B, the manager is going to make that decision. If you have an LLC that has a lot of members or that has a few members, but one person is going to be doing the majority of the work, this usually makes a lot of sense. They're still going to need member approval for certain things, mergers, dissolutions, conversions, domestications, all sorts of big corporate steps that fundamentally change the nature of the entity. But you can also set your LLC up so that other things require member approval and require the members a certain percentage of vote that can change based on what the thing is. LLCs are really flexible. You can kind of do whatever you want to. You can also have more than one manager. So let's say that you have 100 people, 100 members of your LLC, and you want to have a board of managers that consists of 5 of those members, and they're going to make decisions together. You can do that and set it up that way. The difference is whether or not every single member needs to be involved, essentially every single decision. In member-managed entities, LLCs, members are going to make all of those decisions based on votes. They can, through resolutions, delegate authority. So, for instance, you can say, Jim, we're going to buy a piece of real estate. We've decided we're going to buy a piece of real estate. We have a rough idea of the price. You go deal with the document, sign everything, and make it happen. But the members still have to be involved in that conversation and have the opportunity to vote on that decision. Generally, manager-managed is going to be a little bit more expedient. With member-managed is going to be a little bit more difficult to move, going to be a little bit harder to get things done, but does keep everyone involved more equitably. I forgot to say at the beginning, if any of you have questions, please feel free to type them up or feel free to ask. At any point in time, I'm happy to answer questions as we go. I'll have time for questions at the end too, but please interrupt me. So taking a look at the single member operating agreement again, you will see that, the multi-member operating agreement, which is slightly different. It's the one without page numbers, just to confuse you all. This explains both how members vote. So that's Article 7, meetings of the members there. And it covers when meetings have to be, how they're going to be formed and handled, who has to show up, how many people have to show up. So if you have 100 members, how many people do you have to make a decision? 51, 80, what percentage? Those are all questions that you get to answer and how they act. Article 8 is a manager section. So this is a section on how the manager works.
Which page is that?
That should be on page 6. That should be Article 8. Keep going. Somewhere right in there. There it is. Perfect. Rights and duties of the manager. So hopefully you see that on your screens now. There are a couple things that you can do here with a manager managed thing. You know, you need to set forth how they're going to be elected, when they're going to be elected, what their term is, what their powers are. So you can give a manager really broad powers and say, go run the business and make it work. Or you can set aside specific powers and say, you know, you can purchase real estate up to $100,000. Anything over $100,000 is going to require member approval. As I said before, LLCs are incredibly flexible on how you run them. And so you can control that balance of power a great deal with your operating agreement. Once again, getting that right depends on your situation, what you're doing. You should definitely speak to an attorney if you have any questions. In smaller LLCs, that may not necessarily be an issue. You may not need to address that quite as thoroughly. So for instance, if you have a single member LLC, giving the manager broad managerial powers probably isn't going to harm you, since you are likely the manager and making all those decisions anyway.
We have a few questions, Chris.
Yeah.
Is it best to use templates to create my own operating agreement? And if so, which templates do you suggest? And then I have two more after that.
So templates can work. I think that they are best used when you have a single member LLC. So when there's just one of you and there aren't going to be a lot of disputes unless you're schizophrenic and have multiple personalities, you're going to fight with each other. If that's not the case, and you have a single member LLC, then you're probably okay using it. If you have more people involved, particularly people, hesitant to say this, if you are either uncertain about those people or you think it is likely that there's going to be a dispute, sometimes the people you know are the people that you are most likely to get into a dispute with. So I'm not sure that knowing somebody since you were 4 really does you that much good. But if you think that there's any possibility that they're going to be, and there will be disputes, and that you aren't going to be able to resolve those amicably, I strongly recommend that you do it.
Thank you. And then, does it have to be notarized?
No, it does not have to be notarized. You just have to sign.
And what finalizes the operating agreement between a multi-person LLC or a single member?
So the difference is less in structure, or less in form, and more in how the entity is actually set up. So for instance, in a single member LLC, I may just exclude the entire portion of the entire article that covers voting for members. Why? Because you don't need to have a meeting and vote to yourself and record your own vote to do something. You can just go do it. Generally, single member LLC operating agreements are able to be substantially shorter. I think the one that I gave here is somewhere around 10 pages. The one for multi-member LLC is a lot more complex, but it's closer to 30 pages. Just covers a lot more issues. If you think about operating agreements and governing documents in general as being a contract by which you're going to be governed for purposes of the LLC, having it in place, having a robust one in place, if you have more than 2 people, is going to be very important, more than 1 person. If you have 1 person, it's more formality. That doesn't mean that there aren't elements that need to be there, that you shouldn't handle things in accordance with the operating agreement. It just means that it can be a lot simpler.
I have another one, just whenever you're.
Go for it.
I am long-standing sole proprietor. I'll be hiring my first employee this summer. What would be the benefit of me becoming a single member versus remaining a sole prop?
So we discussed this a little bit. I don't know if you guys have access to archives, but I discussed this in a lot more depth when I was here last month. But generally, being in an entity is going to protect you to some degree from liability. So as an example, you hire an employee, your employee goes out and does a terribly negligent job building the deck. You assume you built for no reason. And your customer falls through a rotten board in the deck. Your employee was negligent, didn't check on him correctly, and you get sued. Well, when that happens, you're going to have personal liability. It means that your former client is going to be able to sue you and get damages that could be inclusive of your car, your house, pretty much everything that you own personally. By forming an entity, by putting everything in an LLC, you have limited your liability to things that LLC. So that's why they're called limited liability companies. They're trying to cut off your liability individually personally for the negligent or other acts of your LLC. So in that situation, your LLC goes out, or your employee goes out, negligently builds a deck, customer falls through it and sues you. It can only access the funds that you have in your company bank account instead of your personal bank. It can only access if you have a truck that is owned by the LLC. They might be able to get at that, but they aren't going to be able to come to your house and start taking your things. So if that makes some sense, any other questions?
Not so far, but
Perfect.
again, if anybody has a question, please either drop it on the chat or ask it on the Q&A, and then we'll be more than happy to ask Chris about it.
Absolutely. So can I get the next slide there? So as I was discussing, when deciding how your LLC is managed, if it's been a manager managed, you're going to want to include in the operating agreement information about how managers get elected, when they get elected, what their term is, their powers. Again, are they broad or enumerated? Do you want to indemnify them? So they can have some potential personal liability there. If somebody sues them, they may have to pay legal fees to defend themselves. And the company may want to or be willing to indemnify them, which just means pay for their costs and stand essentially in their place. So they're going to be paying for it. If it's member managed, you'll want to address this anyway because your members likely have to vote on things, but the rules for voting, quorum, which is the number of people you need to show up before you can actually have a vote. How much notice do you want to give of meetings? So for instance, do you want to be able to say the night before, hey, we're having a meeting tomorrow night, or do you want to have to wait a week so that you get a chance to know what's happening? You also have the issue of the percentage necessary to approve an action that the LLC wants to take. You can adjust this, and it can be adjusted based upon what the action is. So for instance, maybe you say to dissolve the LLC, you need 80% approval. But again, to buy a piece of real estate, you need 51%. To the next slide, please. So that's sort of the management aspect of an LLC, and that's one of the things that definitely need to include an operating agreement. In a equity structure is another. So who gets paid, how, when? Sort of the first issue that you can address here is membership units versus percentage interest. There's some LLCs have membership units, which function a lot like stock. They don't exist. There doesn't have to be a piece of paper, but you have a certain number of units. And those indicate the interest that you have. So for instance, let's say that you have 10 out of 100 units, you would have a 10% interest in the company. You can also just bypass that step entirely and make it a percentage interest and say that you have 10%. Not a big deal, but one of the decisions that you may have to make in setting this up. The difference is primarily academic. It kind of depends on what's going to be easier to handle for you in the situation. Distributions. So distributions are when the LLC has extra money and it gets to give it to you. The goal of starting your own business is to have it from you. So the first thing to know about this, and you should have a provision in your operating agreement that talks about and discusses distributions, and in particular, when they can be made. Legally, you cannot make distributions if making a distribution would leave your LLC insolvent. So that means that it doesn't have enough money to pay its debts going forward. Now, that doesn't mean that you can't have a negative balance and make distribution necessarily. You just need to be able to continue operating just like a normal business and continue to make payments on your debt. So for instance, if your company and you have $200,000 in cash and you have a $500,000 loan spread over 30 years, you can still make a distribution. You just need to be able to make recurring payments on that $500,000 loan. Beyond that, again, LLCs are very flexible. You can say that we want annual distribution. You can say that every 6 months we would like the manager to decide whether or not to make a distribution and if it's legal to. One of the things to consider in doing this is initial capital contributions. So when you start your business, you're going to put some money in the bank, you're going to bring some property with you, you're going to perform some work for it. Those things are your initial contributions. They are what's going to make the entity, the LLC function. Hold on a second.
And I got 2 questions when you're done with that.
I will take the questions.
All right. Is the operating agreement the place to outline passage of shares for members that manage the LLC?
Can you repeat that?
Is the operating agreement the place to outline a passage of shares for the members that manage the LLC?
Yes, that is one of the things you put in there. You can authorize a certain number of units that can be issued with the function, exactly like shares of stock of a corporation. And you can say, for instance, that there are going to be 10,000 outstanding. You're going to issue 1,000 of them. You have 9. The company has 9,000 units left that it can sell going forward.
And then I have 2 more.
Yep.
Are there any drawbacks for husband, wife to create a multi-member LLC as opposed to just one established LLC? And is a multi-member LLC the same as a LLP?
I'm going to answer the second question first. No, it is not an LLP. We're going to talk about limited liability partnerships going forward. They are very different. I highly recommend starting a LLC and not a partnership of any kind. But we'll get there. I'm sorry, what was the first question? Is there a disadvantage?
Is there any drawbacks for husband, wife to create a multi-member LLC as opposed to just establish one?
There are some potential tax consequences. So if you are a single member LLC, the IRS treats it as a pass-through entity, which means it essentially pretends it doesn't exist. I don't believe you have to file tax returns for it. You should talk to an accountant to confirm that. But you just report that on your individual income tax return, and that's a little bit simpler. As soon as you have more than 2 member or 1 member, they start wanting to see tax returns. They aren't terribly complicated. Again, if you have an accountant, shouldn't be a big issue. But that's one potential issue. The other one is what happens upon dissolution, or if you have a dispute between the two. So for instance, again, everything is rosy when you start a business, and it doesn't always necessarily stay that way. Divorce is one of the reasons why LLCs can get dissolved. Perhaps you don't think that's an issue for you, and I hope that it isn't. But that certainly is a risk that is out there, and figuring out how you're going to handle that, who's going to get it. And so, for instance, if you have a business that you operate entirely on your own and your husband isn't really involved, I probably would recommend just going with a single member LLC. But having your husband join you as a partner is far from the worst idea in the world.
2 more.
Go for it.
One is, and I don't know if we were answering it or not, but can a member pay themselves as an employee? Can members pay themselves as an employee?
Yes, is the short answer to that question. Slightly longer answer is that distributions are the traditional way that members get paid. So that's profits that come into the entity that you're then going to pay yourself out. You can, if you are an employee, as an individual, enter into an agreement. It's actually something you can with the company, with the LLC, to work for them essentially. So yes, you can take a salary. There may or may not be tax consequences to that. Talk to your accountant.
And there's one that is related to taxing that. What happens if an S corp does not pay themselves when the income is low for a whole year? Are there repercussions with the IRS?
I don't know. It doesn't sound like a good thing. My understanding about an S corp, about S corps, is that they really do need to pay out a salary, a sufficient salary. But that's a good question for an accountant. I could do some research and probably find the answer. Please email me if that's the situation you're in.
Bring that question to March's bail.
Yeah, and we have a bill coming up in March
Perfect.
with an accountant that's going to be on panel.
That will be a wonderful person to ask, and who should have a much better answer to that question.
Thank you, Chris.
Absolutely. All right, capital accounts. We are going to talk about capital accounts, of course not. Okay, so capital accounts, capital contributions, again, are the first things that you initially put into your LLC. You come and you say, I'm going to invest $10,000 in my LLC, you put that in your LLC's bank account. That's the amount you have there. you should put that into a capital account for recording purposes. Every member should have a capital account. Capital accounts is the amount of money that they've put in and the amount of money that has come out of it. So as profits increase, you're going to put profits into those capital accounts and you're going to distribute them out of the capital accounts. This is solely bookkeeping. You don't have to have separate bank accounts. You don't have to have a different place to put the funds. You just need to keep track of what people have put in and what people have gotten. This is very important. As I'm sure the accountant next month will tell you, you need to keep very careful track of your books and records, and we're going to talk about that a little bit more in a minute. All right, limitation of liabilities. Perfect. There are these things called the duty of loyalty and duty of care that generally apply. This is especially important for managers and manager-managed LLCs. The duty of loyalty says that generally you have to put the LLC's interests ahead of your own. For instance, your LLC is in the business of investing in property. There's a really nice piece of property that you as a manager become aware of that is right across the street from you. You can't just jump in and buy that piece of property for yourself as an investment property. You have to go to the LLC first. Another way that that comes up is if your sister runs a business that provides supplies that you need to produce your goods. You can't go to your sister generally and say, hey, I want to work with you. I want to make sure that we're using your supplies to produce our goods. In LLCs, you can restrict those substantially. The operating agreement is the place to do that. So you can suspend all of them to the fullest extent of law. You can limit them and say, hey, you don't have to, we don't mind interested transactions. It's okay if you want to enter into a contract with your sister or your brother or your son, but we don't want you stealing corporate opportunities. So if you find an opportunity that would be a good fit for the LLC, we want you to bring it to the LLC. Duty of care, similar, it just says that you have to act with reasonable care in conducting the affairs of the business. So, you have to do a certain amount of due diligence before you just agree to buy a piece of property. You have to go look at the property, think about it, see what services are going to be able to get to it, how much you're going to be able to sell it for, and just think about some of the things that a normal person in that position would think about. Once again, that duty can be restricted or eliminated, and you may act as recklessly as you want to, so long as you don't act intentionally or maliciously. Moving on to books and records. This is really important. And I know that this is a really hard thing to do for lots of small businesses, but you have to maintain carefully your books and records. This includes, when I say books and records, I mean your financial books. So money going in, money going out, and all of the legal documents that are related to this. So that would include the operating agreement, that includes the certificate of organization, that includes any contracts that you enter into, your capital account balances, or any resolutions the members pass. Anything that you sign or that is signed by somebody, you should probably retain. If you have a question, retain it. This is particularly important in multi-member LLCs because every member has a right to have reasonable access to books and records. That usually means during business hours, usually with reasonable notice. So they can't come knocking on your door in the morning and say, I want to see the records now. They have to show up Monday, 9 a.m., and then you have to be able to provide it. But if you don't have access to those books or records, it is quite possible that you're going to run into some.
I'm sorry, question. Is it a corporate binder the best place to keep those records?
Yes, if you had a firm like mine that formed your LLC, it's quite likely that you've got some sort of binder. Yes, absolutely put everything. And again, being over-inclusive is going to be better than under-inclusive. That's 3 years from now, when somebody wants to see that one thing from, again, 3 years ago, it is going to be far better to have too much to dig through than to not have the thing that you're supposed to have.
Thank you.
Get a binder, get a folder on your computer, whatever works for you. Just make sure you have it. That's the most important part. They don't necessarily need to be organized. Obviously, it's better if they are, but keep them. That's the important thing. All right, let's talk about restrictions on transfers. In an LLC, you get to decide who you do business with, at least to some extent. There are two different ways that somebody new could come into the business, right? They could buy new units or a percentage interest in the business, or they could buy in the business from the business. So just like you, when you brought in your capital contribution, your initial contribution, you got a certain number of units in exchange for that capital contribution. You can also have more units that can then be sold for another capital contribution to another member. So if Jim and William here have an LLC, they have started and they've been doing pretty well, and I think I'd like to be a part of that, they might let me buy in for $10,000 and have a 10% stake in their business. They're doing really well. Business is valued at $100,000, 12 months. It's very impressive. Alternately, Will could just decide that, he's tired of running the business and that what he wants to do is sell his units to Jim may not like that, because Jim may really like Will and Jim doesn't know me at all. So there are some things that Jim can put in the operating agreement to make sure that he has a way to ensure that he doesn't wind up in an agreement or in a business with somebody who he doesn't want to be in business with. You can require approval of the members. You require approval of 51% of the members. You require approval of 80% of the members. You have rights of first refusal, which are the opportunity. A right of first refusal essentially says, before I can sell this to anybody else, I have to give you the opportunity to buy it on the same terms. So I offer Will $10,000 for his membership interest, and Jim says, well, I'd just buy you out for $10,000. Will gets the same deal. I just don't get to be part of the business, and Jim would never put up with me. You can also set up a system for the LLC itself out of its own account to buy back units or membership interests. This is called a redemption. And so Jim, through a vote, could say, instead of selling your units, we're just going to buy them back so that you don't exist anymore. Your membership units are no longer outstanding. You just aren't a partner of the business. When you think about some of these things, particularly redemptions, think about what is a fair and equitable way of determining how much you're going to pay somebody for a redemption. This again is going to be covered a little bit more later when I talk about disputes. One other thing that's very important, any new members do need to accept the operating agreement. There are documents, I'm sure you can find one of these online. These are pretty simple, that just say basically we agree to be bound by the operating agreement dated X of such and such LLC, and they sign on that. And that goes with your records, your books and records. So on pages, and you don't have to go through right now, 14, 15, 16, Article 11 of the multi-member LLC operating agreement, you have a transferability provision there. And so this is a lot of legalese on a page, I know. But this is basically governing how and when people can transfer their membership interests.
See, what's 11?
Starting on page 14, yeah. Almost there. Right at the bottom. And so, as you see here, the very first sentence of this one is, except as otherwise specifically provided herein, no member shall have the right to sell, assign, gift, pledge, hypothecate, fancy word for transfer, exchange, or otherwise transfer, with or without consideration, either voluntarily or by operation of law, or as a result of the death of a member, any part of his or her membership units or membership interest, without the express prior written consent of the members who own at least 2/3 of the issued outstanding membership. In essence, if you have membership units, you can't sell them unless 2/3 of the other members have approved it.
That could be set, Chris, by anybody. I mean, it could be
Yeah, that could be
51%.
51%, could be 20%, can be any percentage you want to, and you don't have to have this. You can say that you can freely transfer your membership units to whoever you want to, whenever you want to. Generally don't recommend that unless you're operating something that looks a lot more like a corporation, and then you might want to think about being a corporation, but you can do pretty much anything you want to. Turning to termination and dissolution. Again, when you start a business, everything's rosy, everything's wonderful, you're going to make a bunch of money, it's going to be great. But you need to think about what's going to happen when things aren't great, or when you're done with the business, when you've made a bunch of money and you're ready to move on. So when does an LLC dissolve? Does it dissolve if one of the members dies? Does it dissolve if all the members die? The members can approve dissolution at any point in time. That's a statutory requirement. The court can order you to be dissolved. What about other situations? What if you have a divorce? What if a member's insolvent? Do you want to have an insolvent member making financial decisions for your company? Can't make financial decisions for himself terribly well. And when it does dissolve, what's going to happen? How are distributions going to be made? Generally should follow the ownership, interest, and capital points. There's also a process of winding up, which is a really general term for operating the business until the business closes the doors, getting rid of excess stock, paying off debts, doing all sorts of things that you just have to do to close your doors. You can do that after you've said these. All right, so I'm going to stop again very briefly. That's sort of the end of the operating agreement section. I moved, I think, reasonably quickly through that. So if you have any questions, now is the time.
If you have any questions, again, make sure to drop them in the chat or on the Q&A. I said right now, I don't have any questions so far.
Perfect.
Then we have answered them all. But again, if you do have one, feel free to drop it and then we'll try to stop and answer them as we go.
All right. So we're going to talk about bylaws and corporations. So the bylaws are essentially, it's not true. Bylaws are a lot like operating agreements. They just govern how things are going to get done at a corporation instead of an LLC. Bylaws, unlike operating agreements, are fairly rigid. Corporate structures are determined by statute, fancy word for law, and most of what has to be in bylaws and most of what bylaws can say is already set out in statute. There are things that you can tweak, and it may be beneficial to tweak those things, but the range of things that you can vary is substantially narrower than it's not. So we're going to talk about shareholder voting, board of directors, officers, equity structure, and books and records here today. So as you can see, as promised, if you look at the bylaws, page 1 bylaws, exactly like, just like the LLC, the name is there, principal office where you get your mail, the registered office, who your registered agent is, etc. All shows up right there. It's pretty straightforward stuff. Now we're going to talk about shareholder voting. You can leave that up there for a second. So shareholders only vote on a few things as a general rule. They're going to elect directors. This is probably their most important function. And then they also are required to approve dissolution, mergers, domestications, or conversions. I should probably explain what those are. Dissolutions is closing your doors. Merger is when another company decides to essentially buy you out and kind of merge to form a different company. Domestication is if you move to a different state. So let's say you start a business in Nebraska, but you do all of your business in Iowa and you decide that tax laws are better in Iowa and you want to go to Iowa. Domestication is how you get there. Conversion is when you have an LLC and decide what you really want to do as a corporation. Can actually legally make that. As you can see here, there are 2 different kinds of meetings, annual meetings and special meetings. So annual meetings are generally where you're going to elect directors. Special meetings are generally going to be where you're going to do one of those other things. Dissolve the company, close doors, approve a merger, something like that. Both of those things require notice. Notice has to be sent to shareholders. Doesn't matter if you're the only shareholder, you have to send notice. You can waive notice. You don't actually have to send notice. But if you have more than one member, send notice. You have to have at least 10 days and no more than 60 days. Again, these are statutory requirements. That should be outlined. You see that there's section 3 there is the notice of meeting section. Set forth exactly what's in the statute. That's pretty standard. All right. So shareholders don't get to do a lot by default. But boards of directors, if you didn't know, should do. And you have a lot of decisions when you form a corporation to make about the board of directors. How many directors are there going to be? How long are they going to get to be there? How are they going to be elected? How are you going to fill a vacancy director decides to, retire, move on, do something else with their lives. What is the quorum? Again, just like with members in LLCs or even with shareholders, you have to have a certain number of people to vote. How many? Once again, you have to have regular and special meetings. You have to give at least 2 days notice to board members for special meetings and not for regular meetings. Regular meetings are generally going to be monthly or quarterly meetings where the board of directors gets together and discusses where the business is headed. One of the final things that you're going to discuss is compensation. So how much does the board of directors get paid, if any? They don't have to be paid, but they can be reimbursed for their cost or expenses. So for instance, maybe you got somebody who's coming from Lincoln, you're going to pay his gas every time he comes up to Omaha from you. One of the things that I want to touch on briefly, and I apologize if this is going to be confusing. I know that it's going to be confusing because it confused absolutely everybody in law school who had to deal with it. By default, when electing directors, there's a process called cumulative voting. You can switch me to the next slide here. I'm going to try to keep this simple. I'm not a math person. As far as teaching a little bit of math. Cumulative voting essentially multiplies the number of shares you have by the number of director positions there are to come up with the number of votes you get in total. You can spread those votes across anyone. I have an example on the screen there. Got Joe, Alice, and Megan. They each have 100 shares of stock. Since there are 3 director positions, each of them get 300 total votes. They can vote for John, Jim, Maggie, or Sarah. If Joe can vote all of his votes, all 300 of them to Maggie. Alice splits her votes between Jim, 100 votes to Jim, Sarah for 200. Megan splits her votes evenly between John and Jim. So the 3 top vote getters, in this case, Maggie, got all 300 of Joe's votes. Jim, who got 150 of Megan's and 100 of Alice's, and Sarah, who got 200 of Alice's votes, are going to be elected directors. If that didn't make any sense, don't feel that. It's a really confusing system, and you can change it. You can have what's called straight voting, where you have 100 shares, you can vote across, split any way you want to. This is a slightly more equitable method, but if that confuses the heck out of you and you don't have to think about this every time you elect directors, you may want to choose to go with straight. So the board of directors doesn't actually run things. The officers run things. And so the board of directors have to appoint the officers. It is required that you have officers, but not specifically which officers. You need to have at least a president. The president is going to be who's going to run your day-to-day affairs. You'll also hear, if you hear about CEOs, same exact position, doing effectively the same thing. Generally, there's a president, 1 or more vice presidents, secretary who's going to keep minutes for meetings and generally assist with things, and the treasurer who's responsible for the money the business spends. Doesn't have to be universal, but those are the most common officers that there are. In your bylaws, you want to set forth specifically the powers of it. So for instance, if the president wants to spend more than $50,000, maybe he needs to go get the treasurer's approval, and both of them have to sign off on it. You have a lot of control over how much power and what power each of these positions has in your bylaws. That's one of the few places where you have a fair amount of an opportunity to determine these things. Once again, you need to settle on a term. How long are they going to serve? Do you want to be there for 1 year? Do you want to be 5 years? What's that look like? How do you want to be able to remove them? So can the shareholders call a special meeting and have them removed, or is that solely a board of directors decision? How are vacancies going to be? When are vacancies going to be? What sort of compensation are your officers going to be paid? All of these things can be delegated to the board of directors in the bylaws or set forth more explicitly. You can say that your CEO is never going to make more than $100,000 a year, period. That's the salary. That's all it is. Doesn't matter if it's 2067, $100,000 doesn't buy you stickers. You make $100,000. All right, moving forward here for a minute. If you want to take a look at the bylaws there, you can see some of these articles. Article 3 on page 4 is a good sample of board of directors. Again, it's going to walk through a lot of those things I just talked about. Their powers, how many of them are, what they need to do, their election and tenure, vacancies, etc. Page 6 and Article 6 are going to show you, are going to do essentially the same thing for officers. But I'm already taking too much time, so I'm trying to move a little bit faster. For equity structure, dividends are exactly like distributions in LLCs. You can't make them if you make your corporation insolvent. You wouldn't be able to pay your bills as they come up. And dividends have to be authorized. Once again, though, you can direct the board of directors to issue dividends when possible every 6 months, every year, every 2 years, whatever you want to do. One of the things I'm not going to talk about in depth is that you can also have different classes of stock. So you can have classes of stock that are going to get a smaller percentage of the profits, classes of stock that don't get the vote, but get a percentage of the profits. Those are all issues that you're going to need to address in your bylaws to the extent they are relevant. Just to emphasize the importance, books and records, keep them. We talked about this. Shareholders get to have access, but their access isn't quite as broad as LLC members' access. They get to access them during business hours with 5 days written notice. There's some more complicated rules there, but by and large, that's what you need. Moving on to my least favorite kinds. Actually, I'll pause there for a second if anybody has questions about bonds.
Not so far,
Good
but if
deal.
you do have any questions, feel free to drop them in the Q&A or on the chat.
Now we're going to talk about partnerships. Partnership agreements are a little bit different because partnerships are a little bit different. Partnerships are just two people who split profits and split costs. That's just about it. If you have more than one person and they're splitting costs and they're splitting profits, you have a partnership. You don't need to have a partnership agreement to have a partnership. If you have a partnership, you should have a partnership agreement. It is not governed by statute. So the law doesn't tell you what has to be in one or what doesn't have to be. You get to decide what it is. This is essentially just a contract between you and your partners. Some of the things that are very good ideas to have in a partnership agreement, and I apologize that I don't example this. I don't do very many partnerships because I don't like partnerships and I don't advise most times to go with partnerships unless they have a really compelling reason to do so. But the ownership interests, who owns what, how much, what's the breakdown there? The authority and decision-making process. Unlike with LLCs and corporations, that isn't clear necessarily, and so you need to set that forth. The allocations of profits and losses, who's going to get the profits, and perhaps most importantly, dispute resolution and then termination. So firstly, for ownership interests, how much does each partner own? Once again, unlike with LLCs and corporations, there isn't a rule out there that says how this has to be. You could put 50% of the funds in and still only get 20% of the profits. That's perfectly fine if you agree to it contractually. However, I would advise considering the initial contributions of partners, the amount of labor that they're going to be putting into the business, the expertise that they're bringing to the business, the other property that they put into the business, whatever. It doesn't have to be equal between all the partners. You know, you can have 2 45% members or partners and one 10% partners. Not going to do a whole heck of a lot in 2 45% partners. Authority and decision making. How do decisions get made? By a vote of the partners, by managing your administrative partner. You can set up somebody to make the day-to-day business decision, or you can let everybody have a say in how it's run, a lot like an LLC. One of the important things to note is that by default, each partner has the authority to act on behalf of the partner. So each partner individually, without knowledge or approval of the other partners, can go out and enter into a contract on behalf of the partnership. You find a supplier you like and you say, hey, I feel like agreeing to buy $250,000 worth of your supplies over the next year. You can do that, and the other partners don't get a say in that inherently or by default. You can restrict that through the partnership agreement to some extent. And there's more rules out there around that, but avoid just having all of your partners running around doing whatever it is that they think is best without consulting each other. Set up a system. If you're going to have a partnership, you should have a partnership. If you have a partnership, set up a system that is going to be productive and that is going to make that decision-making process a little bit quicker. Once again, there are duties of loyalty and care. You can waive those to agree in partnerships. Also, you should consider compensation for partners who are performing special roles. So if you have, for instance, if I'm brought in to be a legal advisor in a Raymond James partnership, and I have a 10% interest there, you might consider paying me a salary for the services.
We have a question, Chris. If your company is incorporated in one state, in this case Delaware, and its place of business is in another state, in this case Nebraska. In this example, does Nebraska corporate law supersedes Delaware's corporate law?
No, Delaware corporate law is going to govern how the corporation is managed and run. The bad news, all the advice I've given you here tonight is primarily geared toward Nebraska. The good news is that there's this thing called the Model Business Corporation Act, which put together by a bunch of really smart legal minds, and it's a statutory scheme, and by and large, most states look the same. There are exceptions. Delaware has some friendlier laws in some ways. A lot of that's going to be tax stuff, though. And so the advice that I'm giving you here tonight is probably going to be applicable. You are, once again, talk to an attorney. And an attorney in Nebraska, by the way, is perfectly capable of helping you press Delaware. So you don't need to go to Delaware to find Delaware prices.
Thank you.
You are very welcome.
And again, if anybody has questions, feel free to drop them on the Q&A or on the chat.
All right.
Yeah. So what legal tool can I use to find to share process there? And then
So either an LLC or a corporation.
sure that what kind of agreement?
So you're going to want to somehow get a membership interest to the person who you want to ship. So that could be a purchase and sale agreement. You could just issue more units from the LLC. You could sell some portion of your units for your membership interest. A pretty simple sales agreement is probably what you're looking at.
Chris, would you be kind enough to repeat on the mic? What was the question?
Yes, absolutely. The question was, what do you do essentially if you want to share your profits, if you want to have somebody partner in your business with a partnership, just in any form of business? And I'd be happy to discuss that more. I'd be happy to discuss that more with you after. Yeah, of course. All right, we're going to talk really quickly. I know somebody brought up limited partnerships and limited liability partnerships. We're going to talk about what those are. So a general partnership is what we've been talking about. A limited, wherein one of the keys of a general partnership is that every single person is individually liable for all of the business debts of the company. So again, if I decide to go out and enter into a contract for $250,000, my two partners now are personally liable. Their homes, their cars, their dogs, whatever, are on the line if we don't pay that $250,000 contract. That's not a great thing in my mind. Limited partnerships try to address this by having what's called a general partner who's going to be responsible for the day-to-day operations of the business, is going to make all the business decisions, and he or she alone is going to be personally liable for the business debts. And limited partners who are essentially silent investors. They're not personally liable for the business debts. They're not going to have a lot of control over the daily operations. They probably get some say in deciding what there is and some of the bigger decisions, but they are much more hands-off. In exchange for being more hands-off in a limited partnership, they are not personally liable for the debts of the business. A limited liability partnership looks a lot more like a general partnership than a limited partnership, except that each partner has, to some degree, limited liability. The extent of that degree is basically that they're not going to be liable for tort damages of other partners. So if your other partner goes out and does something negligently and gets sued, in a normal partnership, every partner will be individually and personally liable for the damages for his negligence or negligence. If in a limited liability partnership, you're not. That's the extent of the limited liability. You're going to get a lot more of a limitation on liability in either a corporation or an LLC. This is a lot of professional organizations do this, so doctors, lawyers, accountants. Because of the commonality of practice suits, And so the limitation on liability, that's the biggest potential liability, is simply suing the individual. And so by cutting that liability off, we've essentially gained all of the limitation. But each partner is going to remain personally liable for all of the debts of the business. Allocations of profits and losses. Again, this is usually going to be based on the ownership interest. You can't alter that and change how much people are going to get paid. I would strongly recommend, if you're in a partnership, using something like an LLC's capital account system. I think that that's one of the most equitable, fair ways to go about this. As always, dispute resolution. What are your options? How are you going to handle it if you have a problem? Are you going to go to mediation, formal or informal mediations? And I can just say, Jim and I get into a dispute, we're going to go to Will, and Will's going to resolve that. We both decide beforehand, so none of us can be mad when Will doesn't side with us. One of us will be mad. You can go to arbitration, which is a sort of more formalized version of mediation. It's a lot like a trial, but it's cheaper and faster generally, which can be advantageous, or you can go into litigation. You also have options to buy out. You know, who's going to be buying out? What's the buyout price or formula? How are you going to decide what that payment looks like? For termination of a partnership, the default rules: if one partner decides to quit, the whole thing goes down. Partnership terminates and winds up its business. Your partnership agreement can change that. You can decide, you know, what percentage of partners have to want out for the other partners, you know, are no longer allowed to keep going. If you have named partners, do you get to keep names, or do they go with partners? How are you going to pay dissociating partners? So if I say, hey, I'm done with this, I'd like to go home and I want my cut, how are you going to pay me? Is that going to pay me one lump sum? That can be really hard if you have a really successful business and my lump sum is worth $200,000 or $2 million. You may not have that sitting there. Thinking about these things beforehand is going to be very advantageous. This leads me to my final discussion point, which is just a general one. This has nothing to do, this is not about partnerships specifically. Decide how you're going to handle disputes before you get to disputes. Said it 4 times. Everything starts out rosy when you start a business. You're going to make a bunch of money and everybody's going to be really happy. And you will have disputes. You will reach a point where you disagree about how to proceed. Figure out what that looks like. Use that positivity at the beginning to decide fair and equitable ways to resolve the disputes that you will undoubtedly encounter in the future. So think about buyouts and buyout formulas. Think about rights of first refusal, the opportunity to buy things. Decide, if you've got a 50-50 LLC and you can't agree on how to go forward, which one of you gets to keep operating the LLC? Maybe neither. Maybe you dissolve it right then. You know, how are you going to handle a deadlock where you both want the LLC to continue and you think it's successful and you want to keep working on it, but you can't make a decision because one of you is dead set against something, one of you is dead set for it. You know, you can make some possible solutions to have somebody have 51%, somebody have 49%. So if you get to a deadlock, one person's going to get to decide. You can, again, have mediation, either formal or informal. Decide beforehand, we're going to take this to so-and-so, or no, we're each going to select a mediator, and then those 2 mediators are going to select a 3rd mediator. And that's how we're going to come up with a panel of people to help resolve our differences. You can say that we're going to go to arbitration. Or you can say you're going to go to litigation. I don't recommend this. Just as a note, this is not something that only small businesses deal with either. We have plenty of large, very successful clients who decide they don't really need to think about this. They're going to make a bunch of money and everybody's going to be happy. And 3 years later, they get to spend a lot of money on legal fees that they would rather not spend on legal fees to resolve an issue that they probably could have resolved if they'd just taken the time to think about it. So if you're just setting up an LLC, or if you already have an LLC and it's going swimmingly right now, I strongly encourage you to figure out how you're going to resolve differences as they go. And with that, I will end my presentation. I was short last time. I think I'm this time.
Well, Chris, we want to thank you. Cline Williams, thanks to Cline Williams for allowing Chris to come here and share with us on SourceLink. Scott's with me with SourceLink Nebraska, Greater Nebraska Women's Business Center, Rowan, Nebraska, Omaha Chamber, and NBDC are some of our other sponsors. With that, though, we do want to open it up for some questions. We probably have time for about 2 or 3 questions. tonight. I want to stress one point Chris already made though, and that's how important it is to make and document your decisions when you set up or when you add a new owner, new person to the organization. Disputes happen, but if you have it written down ahead of time, you'll know how to handle them sooner and probably more amicably. So even though Will might get stuck in the middle, it might be easier for him to say, here's what you guys agreed 3 years ago when you were all happy. So here's
How we're
why
gonna do
it's
that.
going to be that way. So
Yep.
Will, thank you. Yeah.
Thank
So-
you. I don't think I have any questions. Oh, never mind. Just pop one in. Could I see the last slide? Or we'll receive. Chris, can we distribute the PowerPoint?
Absolutely.
Also, this is going to be uploaded to our YouTube channel where all the series is going to be there. So if you go there, we have episode 1 of last month, and then this one is going to be up there too. But also, Chris was kind enough to let us know that we are able to share the slides and the sample bylaws and agreements. So we'll be sending that out over. So thank you so much. Again, if you have any questions, I don't see any other than that.
Just as a note before you send that out, PowerPoint slide does not constitute legal advice. The presentation does not constitute legal advice. The wonderful samples that I've given you that are papered with various disclosures and watermarks do not constitute legal advice. Don't sue me if you get in trouble because of what I said. Talk to your attorney.
Well said. All right, it looks like everybody's saying thank you very much. This was very helpful. I appreciate it. Thank you, Chris. Thank you. All right, everybody, if there's any other questions, you can either email us and then we'll be more than happy to either bring it to the next session or see if we can get information for you. Again, Jim, the next one is March.
21st is the bail.
And
So
it's gonna be,
we'll do hybrid again. So we'll have a lawyer, well, banker, accountant, insurance agent, and a lawyer. So you'll get all of those questions you stumped Chris with today. Great job, folks. But you'll be able to ask the accountant that question and get the accounting profession, or you might have an insurance question. And so come prepared with your questions in March. We look forward to them.
awesome. Well, other than that, thank you very much, everybody. Chris, thank you so much for your time.
Of course, thank you for having me.
And I'll see you guys. We'll talk again next time.
Great.
Well,
We'll spend time with you.
Yes, happily. It's really nice to meet you, man. Sorry that I used you for all of my cases.